The Nigerian judiciary has a date with history. Never before has the anticipation and the anxiety been so heightened as it has been in the past few months since the Presidential Election Petition Court commenced sitting to review the conduct of the 2019 presidential election. Before now, most Nigerians have had their opinion on whether or not the election conducted by INEC met the minimum standards of what an election should be, especially for a country that for many years had fought for the overthrow of military dictatorship in favor of democratic governance. Elections are one of the hallmarks of democratic rule. But in Nigeria, the nature in which those elections are conducted have always been reminiscent of the jackpot era. But it has been a slow journey to getting things right and ensuring the integrity of candidates and their claims. When in 2015, the Mahmoud Jagal-led INEC conducted a presidential election that resulted in the overthrow of an incumbent president, it was widely hailed both locally and internationally as a signal to the remarkable progress in Nigeria's electoral process. But if the 2015 presidential election was a watershed moment in Nigeria, 2019 turned out to be a regrettable blight on the efforts of the previous 4 years, a fact that has been attested to by several reputable domestic and international election observer missions. For instance, the European Union Election Observation Mission to Nigeria in its final report concluded that the 2019 elections was marked by, quote, severe transparency and operational shortcomings and electoral security problems. It added, there were insufficient checks and transparency in the results process, with journalists subjected to harassment and intimidation by security operatives. The NDI-IRI joint report made similar conclusions, noting that, quote, the 2019 general elections fell significantly short of the standards set in 2015. The highly reputed Nigerian-based Center for Democracy and Development, CDD, also concluded that the collation process was, quote, chaotic, open to manipulation, and in some places badly disrupted and opaque. Another reputable election observation body, Yaga Africa, noted that the 2019 elections presented an opportunity for Nigeria to consolidate on the gains of the 2015 elections and deepen her transition, but that the elections were characterized by same shortcomings that have marred previous national elections in Nigeria. From the above report and the keen observation of proceedings at the various election tribunals and the Presidential Election Petition Court, many keen observers have their eyes affixed on what the judiciary will do. It is safe to say that the Nigerian judiciary is indeed on trial. Its pronouncement will either reinforce the notion that it is business as usual, or stamp a firm note of authority that Nigeria must not retrogress into a state where absence of credibility was an accepted norm. At the presentation of its joint election report on Nigeria, the president of the US-based International Republican Institute, Dr. Daniel Twining, posited thus, that there is the need to take concrete steps to address the concerns of citizens in order to rekindle faith in the power and possibility of credible elections. The risk is quite potent and imminent. Democracy may lose its meaning with waning trust in elections and the credibility of candidates. The ball is therefore literally in the court, before the justices, whose noble calling, in line with their judicial oath, is to do justice to all manner of men without fear or favor. There is no gainsaying that the judiciary has had its share of public contempt over some decisions which many felt elevated technicalities above substantial justice, the type the ordinary man on the street can see and feel. It is also fair to sympathize with the judiciary over some of the things it has been subjected to through overt and subtle intimidation and arm-twisting tactics by politicians and their agent provocateurs. In a climate of politics without rules, principles, and conscience, it will not be surprising that such has already been deployed by parties to foist an outcome. Perhaps it is pertinent at this point to remind the judiciary and the noblemen who sit on the seat of justice the judicial oath in the 7th schedule to the Constitution and the Oaths Act, which they swore to uphold thus: I will discharge my duties and perform my functions honestly, to the best of my ability, and faithfully in accordance with the Constitution of the Federal Republic of Nigeria and the law. It adds, I will be faithful and bear true allegiance to the Federal Republic of Nigeria at all times. I will well and truly exercise the judicial functions entrusted to me and will do right to all manner of people in accordance with the Constitution of the Federal Republic of Nigeria as by law established and in accordance with the laws and usage of the Federal Republic of Nigeria without fear or favor, affection or ill will. I will always place service to the nation above all selfish interest, realizing that a public office is a public trust. I will always perform my judicial duties diligently and efficiently, and will not engage or be involved in any activity in conflict either directly or indirectly with this pledge. I will, in the performance of my judicial duties, eschew corruption in all its facets. This is the time for the current crop of justices to elevate themselves to the stature and reverence of their predecessors, such as the late Justice Ademola Adetokunbo, late Justice Kayode Shaw, late Justice Chukwudifo Oputa, late Justice Philip Naimeka Agu, and Justice Aloma Mukhtar, to mention but a few. This is indeed a golden opportunity for the judiciary to redeem itself and pride of place in Nigeria's democratic journey as it enters what is perhaps the most crucial week of the year.